So I'm going to give you the first one. Anybody here have kids going to college soon or in college or applying for college, anything like that? Okay, well, indulge me in a hypothetical anyway. Here you go. Congress shall make no law. Again, the 16 words we just had. Imagine the following scenario. Harvard University, everybody here heard of Harvard University? Good, fantastic. Requires applicants to pledge their allegiance to the Pope. If you want to apply to Harvard University, you need to pledge your allegiance to the Pope. So the rules for Harvard now read in this fanciful land that I've constructed. Does that violate either of the religion clauses? 16 words up top, hypothetical scenario on bottom. Does anybody think that if Harvard were to do this, they would run afoul, they would violate any of those 16 words? I'm getting a lot of no's. Why not?
Because they're not Congress.
Good, very good. Most people don't start that way. Usually I get the first answer, and the first answer runs something like, no, yes, go ahead.
It's also not a public institution.
That's
private university.
good, good, good. As both of you have noted, you see those two little green lines appear. It says Congress, right? Harvard, no matter how all and powerful they are, not Congress, right? Everyone agrees. Good. Let's change the facts of the scenario, okay? It's no longer Harvard University. It's now become University of Michigan, okay? Everybody still with me? I'll ask the question again. How does everybody feel now? Would Michigan violate any of those 16 words I put up front? Now I'm getting one slight nod, yes. Two yeses. We can take a, why yes?
Well, because it's a public institution.
Okay, it's a public institution. Now, you're probably wondering to yourself, but it says Congress, right? And University of Michigan presumably is in Congress, and this is a nice opportunity to say, well, the First Amendment does mention Congress, and that's been interpreted to mean all federal branches of government. But Supreme Court doctrine tells us under the 14th Amendment, it's not just the federal government, but also state governments and all their subsidiaries that now can't violate these 16 words. So if we were talking about the 16 words and what they mean, our primary goal for today, the answer so far would be, who does this address? Answer, federal government, state government, and all their subsidiaries. Okay, that's the who. So step one, the who is Congress, all the federal government, states, and their subsidiaries. Now I want to move into the second piece of this. So we know who. Now we need to figure out what, right? What do these words mean? We've got a free exercise clause. We have an establishment clause. What I'd like to talk now about is what these mean, what they cover, who they protect. What I would like to show you over the next batch of time that we have here together is the scope of what's covered is increasingly shrinking. In fact, the way in which it's shrinking both for the free exercise clause and for the establishment clause makes religious minorities more vulnerable in the United States, at least as a matter of law. And then I'd like to talk about some lessons that we can derive from there. So let's start with, what does the free exercise clause protect? Let me tell you a story. Lovely case in 1990. Some of you may have heard of it, Employment Division v. Smith. Lovely case. Two fellows, Al Smith and Galen Black, work at a drug rehab center. And it turns out that although they work at a drug rehab center, they find themselves ingesting a significant amount of peyote. Which they may not counsel their clients to do, but they themselves do. Why do they do that? Well, they do it as part of a Native American ritual. And so they find themselves ingesting peyote. Their employer finds out, and given the nature of the employment, they're not pleased, right? Who can blame them? I understand you have a religious practice. Just the fit over here isn't fantastic. Okay, good. So they're terminated. Al Smith and Galen Black then go ahead to the unemployment office in the state of Oregon. They say, we were terminated, and we'd like unemployment benefits. Reasonable thing to do once again. Now, they ask a following question, the unemployment office. They say, well, why were you terminated? And they say, well, they terminated us because we were ingesting peyote. And so they're told by the unemployment, well, that's cause. And if you're terminated for cause, you don't get unemployment checks. They say, well, that can't be cause. That's our religious practice. You can't discriminate against us, they say, by not allowing us to collect our unemployment benefits because we engage in a religious practice. That doesn't seem right. Okay, this goes all the way up to the Supreme Court of the United States. And the question is, what do we do about all this? Is this, the fact that they weren't given their unemployment benefits by the state of Oregon, does that violate the free exercise clause in some way? Anybody want to hazard a guess what the answer is? What do you got?
I think they lost.
You think they lost. What do you think the right answer is?
They were, because it's a substance that is illegal.
Okay, but they were religiously motivated. Should that count for anything?
I don't think so.
Well, we've got two answers. We got a debate going on right here. Are you a husband? So you're disagreeing with each other on this? Okay. I'm just saying. Okay, good. So we've got a debate right over there whether or not what the correct answer should be. Your recollection, though, is correct. The Supreme Court of the United States says no, the Free Exercise Clause doesn't cover any of that whatsoever. Now, this was a little bit of a surprise. The reason it was a surprise is because there were a whole bunch of cases that had been decided before 1990 where the Supreme Court kind of said, here's actually how we're going to deal with these types of cases. Laws passed by federal or state governments can't burden religion. If you burden religion, you're going to have to answer for it, and so you'll have to come into court, and if you pass a law that burdens religion, you're going to have to explain to a court why you had to do it. This is what's known in the familiar constitutional doctrine of strict scrutiny. You're going to have to say to a court, you know what? I had to achieve something really important, a compelling government interest, and this was the only way for me to do it. And that's why I burden religion. If you don't have a good answer to those questions, the law used to be, 1963, 1972, a variety of cases, the law used to be, no, that violates the Free Exercise Clause. You burden religion, somebody's trying to exercise religion, you place an impediment before them and burden their ability to do that, the Free Exercise Clause says you are not allowing them to freely exercise religion. Everybody with me so far on the, okay, good. But that's not what the Supreme Court says now. The court comes up with a new test, something that had kind of been percolating throughout the 1980s. The Supreme Court now says, forget all that nonsense. Governments are allowed to burden religion. As long as a law is facially neutral, it doesn't seem to target religion, and generally applicable, it's not being applied just to religious people, then the law is fine. Take it in the case before us. The drug law was not written to burden religion, right? The drug law was written because we don't want people taking drugs. Happens to be there's a religion that's now burdened. Okay? Court simply says, that is facially neutral. We're not naming you. We're not saying you, Al Smith, Galen Black, or your particular Native American practice is a problem. We're just passing a law. It's facially neutral. It doesn't, on its face, doesn't apply just to religion. And we're applying it to everybody. Religious, not religious, doesn't matter. And so the court comes up with this new rule in Employment Division v. Smith that says as long as the rule doesn't target religion, it's good to go. Yeah?
What happened at the time of Prohibition
Mm-hmm.
with the use of wine as a sacramental,
So I'm going
both in the Catholic Church and
I'm going to show you a statute. I'm going to show you a statute. I've got a statute coming at the end of this, and we're going to talk a little bit about how we deal with workarounds in this situation. So it's in maybe like 18 minutes, something like that. I'll be coming right back to you. Okay. Now, fine. This seems kind of fair, right? I mean, the general idea is, as long as we're not going after religion, you've got to let government pass laws, right? Okay. I'd like to show you how this plays out. I'd like to give you two kind of contemporary examples of how this plays out. Does anybody remember in 2011 there was a proposed circumcision ban in San Francisco? Has anybody heard of this? Okay, good so far. I'm going to put up on the board the text of the proposed referendum. Here was it was called Prohibition of Genital Cutting of Male Minors, and here's what it said. It is unlawful to circumcise, excise, cut, or mutilate the whole or any part of the foreskin, testicles, or penis of another person who has not attained the age of 18 years. Okay, and they got over 40,000 people to sign their names to this. And what would happen if you violated this law? Well, the penalty was either you got a fine that could not exceed $1,000 and or imprisonment in the county jail for a period not to exceed 1 year. Okay, question. Given what I've told you about the state of the doctrine, do you think, is this okay? Is this constitutional or is it not constitutional? I've got a no on the board, 2 no's.
According to the new test, yeah, it's fine.
I've got 2 no's and a yes. Why do you say yes?
Because it's not targeted at religion. It's a general clause that happens to affect religion.
Okay, what do you think about that?
I said it would not stand up. And it would not stand up because this is specifically, I'm a loyal, by the way,
Okay.
And
Well,
I
I-
wanted to go and be the first test case that day.
You did? Okay. Okay. Well, I'm glad that didn't have to happen. By the way, just as backstory, turns out in California there's a law that says municipalities are not allowed to pass laws that govern medical procedures. This being a medical procedure, ergo, was not put on the ballot. That was just by coincidence. Kind of, if you ask me, lucky. But probably you feel very lucky about that given what you've just told us. So tell me, you think this should go down under the free exercise clause. Explain to me why. You have a pretty cogent argument for it's okay.
First of all, I just want to point out to you, they put in the prohibition of genital cutting. That was
Okay.
to make you think of the female genital cut. They did that purposely.
Okay, okay.
Because it's religion. And
But,
it's,
well, where in here do you see religion? It's a little bit of a small screen, but I'm kind of hoping
circumcised.
that seems like just a word, right?
Yeah.
I mean, we wouldn't say that somebody who gets circumcision who isn't religious wasn't circumcised, right?
Correct.
So what do you think? It's a little bit of a puzzle, right? I mean, we wouldn't have thought before this happened. If I said to you, sure, we can ban circumcision in the United States, would you have said, yeah, that makes a lot of sense. Constitution has nothing to say about that. And yet, it's hard, right? I sense from you, you see it here, but it's hard to point to where the problem is. Let me try to help, okay? Subsequent to this, going on, being a potentially on the ballot in California, here's the organization that did a lot of work trying to promote this bill. They're called mgmbill.org. As you noted, they do a lot of comparison between male circumcision and female circumcision, trying to argue that there are a variety of issues going on. What I want you to note from their About page is none of the text, but this guy, Matthew Hess, here on the bottom. So Matthew Hess is the president of mgmbill.org. He also is a well-known, as some of you may know, cartoonist. Has anybody seen the cartoons? No? Oh, okay. Here he is. He's sitting at home on his bed, and he is also the author of Foreskin Man. Here it is. This is issue number 2. You can go see issue number 1 and 3 and 4 online. I actually really don't recommend it. But anyway, here's the hero in the cartoons. It's a Foreskin Man, hence the name. And he's frustrated by society's failure to protect its most vulnerable citizens, and he's taken up the fight against male genital mutilation, hence MGM. Okay, good. The villain of this particular episode is Monster Mohel. And he has very unfortunate things to say about Monster Mohel in the blurb. If you want to get a sense of the cartoon itself, like your average circumcision in any Jewish community, the mole comes in flanked by 2 armed guards. And along the lines, you get the idea. I'm sorry, I don't want you to miss this one. The mole lost his eyeballs in this particular bit of it. I don't know why. And then the wife is bound up in the corner, by the way, and now the baby with the 40-year-old face is about to have a circumcision. So goes the cartoon. Okay. Now, I laugh about it, but I think most people, from the ADL to a variety of columnists, expressed let's call it severe dismay at the substance of these cartoons. They're kind of shocked by it for a variety of reasons. I mean, it basically, right out of the annals of classic European anti-Semitism, right? The black-hatted Jew, anything you can imagine. And right here, I had a friend who tweeted when he saw this. San Francisco, 1930s, Germany called, they want their cartoons back, and Time magazine ran it. It was a nice way to phrase it. Now, let's think about this for a second. I show this to you not because it's terrible and we should all be aware of it, but does this change how you feel about the constitutional question now? Let me ask again, okay? We've got, you remember the text of the proposed circumcision ban, it's basically no circumcision. Do you now feel any differently about it? I can get blank faces, that's fine. Yeah.
Yes, I feel very differently.
Tell me why.
I'm a non-Jew, by the way, but I feel very differently about it because this is personally offensive to me, and it's offensive to me because it's on so many levels. It represents a heartfelt religious belief that's been practiced for 4,000 years, that is sacred, and sacred to many non-Jews as well, Christians who appreciate the Torah. It's shocking.
Well,
Absolutely shocking that this man who did this could be a sponsor for a bill that actually made it to the point that it did.
so let's think about this for a second, right? I mean, you described for a moment, and I think very eloquently, the challenge, heartfelt religious practice that's going to get shut down. And yet, the new doctrine, what's your name? I'm sorry? Mickey. That Mickey, as Mickey expressed it before, when the doctrine says as long as you're not targeting religion, the law's okay. I mean, this proposed circumcision, does it target religion? Our resident Mohel couldn't find any text, right? He tried, that showed that this is going after religion in particular, right? So, yes.
Where was the medical community? In
Uh,
terms of fighting
That
something
doesn't make
like
any
this?
difference. This is San Francisco.
yeah.
I don't care. I mean,
Go ahead, yeah.
Is the only difference between this case and the peyote case just the number of people who are being affected?
Well, let's just, as it stands, this never went up on constitutional, for a constitutional challenge for reasons I described. There's a statute that says San Francisco is not allowed to regulate
If we weren't
medical
so lucky.
procedures. If we weren't so lucky, yeah, there'd be a real challenge here. Let me say the following, though. When some people saw these cartoons, and this was my reaction when I saw the cartoons, I said, this is the greatest thing ever. Why? Well, you have the person who's sponsoring the bill. He's now written all of this. Now tell me, do you think the bill has nothing to do with religion? Now we can have a little bit of a conversation, right? Well, the person who's sponsoring the bill, I mean, you put this in evidence before a court, and we think maybe this does have something to do with religion now. And so that's something I suggested at one point. And people responded as follows. Well, that's all well and good in San Francisco, but MGM Bill is proposing these types of bills in 46 jurisdictions. Because he wrote these cartoons, does it cover everything? Let's say he resigns tomorrow. Does it still cover it? Let's say, fine, he wrote the bill, but over 40,000 people signed on. I mean, they didn't write cartoons. How do we know when a particular piece of legislation is really targeting religion? If the new standard in front of the Supreme Court is the law is only constitutionally invalid if we're targeting religion, well, how do you know when it's happening? You felt like it was straight out of the gate, right? And maybe this gives us a little bit more of a feeling that potentially it is, but there's not a lot to grab onto. People often don't say the following: I'm passing a bill, and it's because I hate religious people. They're usually not that kind. They don't tell us they're discriminating when they discriminate. Let me give you another example of this problem. Had anybody here heard of the anti-Sharia laws going on around the country? Okay, over half the states have proposed anti-Sharia laws. Let me tell you what these things are. They're basically laws that tell courts, state courts, that they're not allowed to consider religious law in their decisions. Now, this was originally prompted by people who I think are unabashedly against Islamic law. They think it's terrible, evil, and dangerous. And they say these things. They're very clear and apparent about it. The first one that was written in Oklahoma in 2010. There's going to be a bunch of text on the screen now, but I think it'll be okay. Okay, this is kind of what it said. And basically, to summarize, the courts, if they ever are enforcing, reaching a decision, they have to use American law. They can't use any other form of law. Specifically, the court shall not consider international law or Sharia law. This was the first version, 2010. One of the things you notice when you look at it is there are two explicit references to Sharia law or Islamic law. And this was challenged in federal court, and it was struck down. One of the reasons it was struck down is because by targeting a particular religion, it became eminently clear that this violates the Free Exercise Clause. You're discriminating. You'll notice, though, that the title of the slide is Anti-Sharia Law 1.0, because there's a 2.0. And here's how 2.0 goes. I actually debated the fellow that's often tagged with inventing these things, and he was very proud of 2.0. He said, Professor Helfand, you should tell them that it's now facially neutral. He was very excited. And if you look at it now, there's no reference to Sharia law anymore. It just provides for the choice of foreign law, legal code, or system. If you have any type of case where you have a contractual provision that incorporates foreign law or a legal code or system, anything along those lines, then it's not valid in court. Courts can't enforce that type of provision. No reference to Islamic law, just foreign law. Now, where does this get applied? I'm only aware of one case where this has been applied, and guess what kind of law was at play? Of course, of course. But it's facially neutral. You see, we think we know there may be discrimination. We just can't point to it. There's no word on the screen that tells me. They didn't send out a memo to all the state legislatures saying, by the way, we're now discriminating. And if the doctrine before the court now is, if you discriminate, it's a problem, but if you don't discriminate, it's not a problem, that's the type of thing we need. Okay. What I've tried to show kind of on this side of the equation for the free exercise clause is we have a doctrine. The doctrine used to be you can't substantially burden religion. Anytime a law somehow burdened a religious practice, that would violate the free exercise clause. That got shrunk in many ways in 1990. Now it's not enough to find a burden on religion. It's not enough for me to say, wait, if you pass that law, it's going to make it hard for me or impossible for me to practice circumcision or anything like that. Now burden doesn't matter. It's just, can you identify that the law is not facially neutral or generally applicable, what I've been characterizing as, does it target religion or does it discriminate against religion? Okay, that's half the equation one. And before we move on to two, yes?
I apologize, a small tangent. Is this law upheld?
Yeah, so far so good in Kansas. It was just applied in a case Soleimani v. Soleimani. I took the Kansas version. There are other versions. The 2011 decision, a woman had a Mahr contract, which is part of the Islamic divorce process. It ensured that if her husband divorced her, she would be entitled to $677,000. In this particular provision, the court said that we need to be able to protect women, and therefore, in order to protect women, we're going to make sure that she gets no money.
So this
That was meant to be a little bit sarcastic, just if anybody didn't get that. Yes, I'm sorry, go ahead, yeah.
Right. So this says that when you go to court, you cannot choose a foreign law.
That's correct.
Would this also apply whereby, pursuant to contract, the parties agree to binding arbitration, and in the binding arbitration,
Yeah,
they
yeah.
pick a foreign law, and then a decision is made, and the arbitration is final, but you go to court to enforce the arbitration.
So let me say a couple things. One, you're like enticing me because this is like one of my favorite topics, and I'm not going to speak about that now. But no, you shouldn't apologize because I need to control myself. I strongly suspect that in tomorrow's panel discussing dispute resolution and religion, that this will be a topic that'll come up, if not in the presentations themselves, then in the question and answers. But you're asking all of the right questions. It's amazing that the alliance that came out against these laws, everyone from the Chamber of Commerce that was like, we can't incorporate French law when we're dealing with the French corporation, to religious groups, up and down, arbitrators. They did a fantastic job with these laws of alienating so many groups that what has happened over time actually is more and more states have tried to adopt them. They keep on trying to incorporate exceptions into the rules. This only applies to family law. This doesn't apply to corporations. It doesn't apply if your first name is Ted. It's basically just an attempt constantly to try and pick off some of the people because, as you're, I think, correctly noting, at least on one side of it, it covers a tremendous amount. For me, the purposes are just more limited. We've kind of given a blueprint with our doctrine of what we want people who want to discriminate against religion, what to do. And the answer is, just don't tell us about it. That seems like a uncomfortable place to be. Let me show you. That's the free exercise clause side. I'd like to show you the establishment clause side. So I'm going to start with a particular case. Now, the establishment clause, the core intuition, as we mentioned a little while back, the government can't be in the business of establishing a religion. That's kind of why people moved here originally, right? They didn't like the whole idea of state-sponsored religion that borders on theocracy. None of that seemed particularly palatable to the founders, right? So we're going to have an establishment clause that says, government, you cannot establish a religion. Okay. What on earth constitutes establishing a religion? Nobody knows the answer to this question. I mean, it changes. It depends on context. There are a variety of considerations. I'm going to talk about it in one context. Sometimes you have government agencies or subsidiaries who engage in conduct that looks religious. Now, I've said you can't establish a whole church. Not everybody can start pledging their allegiance to the Pope. But what happens when government does kind of lower level things? So here's the type of case I have in mind. It's a high school case. Santa Fe Independent School District in Texas, actually. Vido, here's what they had. They had this process where before every football game, an elected student, would deliver some sort of prayer. And Doe, that's not the real name, it's Doe, okay, good. Doe said, no, you're a state-funded, you're a public school. You are government. And you can't be in the business of sponsoring prayers. I mean, that's a hop, skip, and a jump from telling me I have to pledge my allegiance to the Pope. That can't be the case. Now, here's what this looked like. Imagine, right? You have an elected student, they give the prayer, everyone's there at the football game. So here are kind of some of the facts the court was considering. You have a football game, regularly scheduled, it's on school property, it's school sponsored. You're not required to attend. You don't have to go to a football game. I happen to be an obsessive football fan, so I doubt I would be able to resist, but that's not the type of consideration the court was taking into account. There's no required attendance. Should we think about this as establishing religion? We have at a school-sponsored event, we have prayer. Is this establishing religion? I believe I saw 2 heads nod, 1 yes and 1 no. Why not?
Doesn't seem like it to me. It seems to me voluntary.
Okay, I got a yes.
You have no choice if you're there,
You don't have to go.
but then that being the case, you are being excluded.
Okay, interesting. Okay, so good. So let's think about how we want to think about it. One way to think about this is, am I being required to do something, forced? Another way to think is, how's the person who's being excluded feel? Right? It's not just debate about like drawing a line, but kind of how do we want to view these kinds of cases? Well, here's what the court says, okay? And quoting one of the more famous lines in Establishment Clause jurisprudence, what we refer to as the endorsement test, the court says, no, this is no good. Do you know why it's no good? Here's what they say. School sponsorship of religious message is impermissible because it sends the ancillary message to members of the audience who are non-adherents that they are outsiders, not full members of the political community, and an accompanying message to adherents that they are insiders, favored members of the political community. Now let's think about that. It didn't say you don't have to come. It could have said that. There's what we know as a coercion test in Establishment Clause jurisprudence. Maybe we should say it's only when you are forced to do something. But at least in this decision, we'll see, not in all decisions, the court said it's not about what you're forced to do, but it's how it makes non-adherents feel like outsiders. When we make you feel like an outsider, that's what religious establishment is all about. It's about saying this is everyone's, the political community's religion. You're not part of it. You're on the periphery now. This is at least what the Supreme Court said in 2000. Okay. Now, I've told you what the endorsement test is. I now want you to play Supreme Court with me. We're going to do another case. Here we go. As you probably know, prayer is not the only time that governments sometimes engage in conduct that looks religious. You know, religious symbols on government property, whether it's menorahs or Christmas trees, frequent occurrence, and it's also been a frequent occurrence before the court. In 1989, we had the following case. This is the best picture I'm aware of. This is in the county of Allegheny, in the Pittsburgh courthouse. You'll notice, hopefully, that there is a menorah, a Christmas tree, and there's a sign. There's no way you can read the sign, but here's what it says. You'll have to trust me. It says, during this holiday season, the city of Pittsburgh salutes liberty. Let these festive lights remind us that we are the keepers of the flame of liberty and our legacy of freedom. Okay? I've told you a little bit about the endorsement test. Tell me what you think. Is this constitutional or not constitutional? Here, you can take a look at it. What do you think? Does this endorse religion? Does it not endorse religion?
Endorses some religions.
Okay.
Absolutely.
It's on public property.
Okay, public property. 2 people feel like it's endorsing some as opposed to others. Anybody else?
Well, it's not endorsing religion, but it will be perceived as endorsing religion.
Okay, why don't you think it's endorsing religion?
I don't think so, because they're symbols that we use religiously or non-religiously.
Okay, good. The court phrased the question this way. It said, I kind of used some of the words, does the combined display of the tree, the sign, and the menorah, it sounds like a bad joke, right? A tree, a sign, and a menorah walk, in any event, have the effect of endorsing both Christian and Jewish faiths, or does the display simply recognize that both Christmas and Hanukkah are part of the same winter holiday season, which has attained a secular status in our society? Well, somewhat surprisingly, the court went with the latter. It actually goes on to explain at great length why the holidays are really political holidays, and Long discussion, longest discussion of Hanukkah I've ever seen. I mean, my kids won't. And they just, that's what they say. They say this isn't endorsing religion. They talk about the sign. The sign says, what is this all about? It's about liberty, right? And the holiday of Hanukkah is about, casting off of oppressors. It's not anything religious. It's just a historical narrative, and it's all about liberty. So the court says, and some of you sound like you don't buy it. I don't know if I buy it, but at least this is what the court says in 1989. And the endorsement language, you understand what they're trying to get at. At least you understand when they have to make the claim that it's not a problem, that it's constitutionally okay, they have to explain why people aren't going to feel like outsiders. That's the goal, because if you're making people feel like religious outsiders, then you're establishing religion. Okay, this is all well and good. It actually kind of continued this theme in a set of 2005 Ten Commandment cases. These happened at the same time. It looked like there in McCreary County you had the Ten Commandments up, and then in Austin, Texas, you had the Ten Commandments up. Cases come down the same day. In an amazing turn of events, the court says the one on the left is okay and the one on the right is not okay. They actually had the same words on, well, a lot of the same words on it. Okay, good. That's fantastic. Well, here's what the court said. I'm not getting into local, okay, I don't, you good, you sort that all out, okay, I'm going to go back to California when this is done. Here's what the court said. The reason why the one on the left was okay, here's a map of the state capitol in Texas. And they said, okay, fine, you're right, number 9 over there, that was that 10 Commandments, but there are also all of these up, all these other various types of monuments. And then not all those monuments, but there are all these historical markers. And the court said, when you take all of this, I mean, does this look like we're endorsing number 9? No. We've got all these various monuments going on, and somebody who would walk through and see all of that would say to themselves, oh, this is part of like a larger picture of all, historically significant stuff. You're not endorsing this in particular. Somebody walking by would say it's just a bigger story about human history. And so it's okay. So endorsement works. And people thought, the endorsement test, this way of viewing the world, that we shouldn't just focus on what we're forcing people to do, but we should focus on how religious minorities feel, ascended for quite some period of time. And then we had, just this past year, a case about legislative prayer. This happened in the town of Greece. Here are the 2 plaintiffs, by the way. And here's what they had complained about. Town of Greece had a legislative prayer before the town board's meeting once a month. And you're invited by a county clerk to come pray. Citizens would be attending this meeting because they'd be asking for a variety of things, all the things you ask local government for. People would be randomly selected to give this prayer from the Greece Community Guide. And then eventually that list got consolidated to people who had accepted before. Now for 9 years, the first 9 years of this program, only Christian clergy were invited. So that's about 108 in a row if I can still do math. Good. And 2/3 of these prayers had various religious references like Christ, Jesus, the Holy Spirit, or your Son. Okay, question. Should this violate the Establishment Clause? Government invites someone, a clergy member, to give a prayer. They appear to be, at least for 9 years until the eve of litigation, only inviting Christian clergy. Here's some of the language from the prayer. We have 2 people who have said, no, we think that violates the Establishment Clause. On the left, you have Galloway. On the right, you have Stevens. 2 of them bring this claim before the court, and they say this should violate the Establishment Clause. What do you think about that? Does this violate the Establishment Clause? I got 1 enthusiastic yes, 1 close to enthusiastic yes. Anybody else? You got a has to? I'm getting a lot of yeses. Well, as you may be surprised to learn, the Supreme Court, yeah, go ahead.
Would it depend on how many other clergy are around in terms of if it's randomly selected?
Good question. So it turns out if you read the Supreme Court's decision carefully, it says there's 1 Buddhist temple in town, although there's some confusion about its address. It's in a footnote in the concurrence. I don't fully understand it. And it's right next to Rochester. And for those of you, I'm from New York originally, there are plenty of synagogues in Rochester, but they don't believe there are any synagogues in the town of Greece proper. So that's a fair question. You might want to know, well, how should we think about that? Here's what the court says about all of this, okay? I got some enthusiastic yeses, but the court gave an enthusiastic no. The court says that doesn't violate the Establishment Clause. Well, why would that be? Here's what the court had to say on the topic, okay? I know, a lot of text. Let me underline some of it. That nearly all of the congregations in town turned out to be Christian does not reflect an aversion or bias on the part of town leaders against minority faiths. So long as the town maintains a policy of non-discrimination, the Constitution does not require it to search beyond its border for non-Christian prayer givers in an effort to achieve religious balancing. And then the court goes on to say, as long as there's no pattern that serves to denigrate, proselytize, or betray an impermissible government purpose, then there likely is no constitutional problem. Well, here's what the court gives us with all of that. As long as there's no discrimination, listen, that's who's around. And as long as we're not denigrating or proselytizing, it's okay. 108 Christian clergy come in, nobody else comes in during that time period. That's not establishing a religion. So the court says. Now you may say to yourself, what about this whole endorsement bit, right? How does somebody feel? Clearly at least two people feel a little bit put off when they show up before the town board for a variance, right? And the court says, no, endorsement is not what's going to govern this case. We're not going to focus on how this makes somebody feel, but what we're going to focus on instead is whether or not we can identify discrimination. This should sound familiar to you, right? This is kind of what we saw when we looked at the free exercise clause, right? We don't care whether there's a burden on religion. Can you show me discrimination? We don't care how religious minority feels from the government practice. Can you identify discrimination for me? If you can't, no constitutional problem. So we're told, kind of, as we see the evolution of those kind of 16 words that I said I'd tell you about at the outset. This is kind of where things are up to. If I were describing the new model of First Amendment jurisprudence, what do religious minorities get? Well, government conduct is a problem only if we can identify discrimination. If you can't identify discrimination, there's not much to say. You may think it's there. There may be a cartoon that gives you a sense it's there. You may be kind of like, really, 108 in a row at 93? Couldn't you have given it to somebody else? No. If you can't identify discrimination, then a religious minority doesn't get much protection under the First Amendment. Yes?
Did that ruling effectively overturn Santa Fe v. Doe?
It didn't. This is for peculiar doctrinal reasons. The Supreme Court, for some reason, thinks legislative prayer is different than other Establishment Clause cases. Part of it is because we have a history of legislative prayer going back to the beginning of the United States. And so it's hard to reconcile the idea that the people who wrote the Constitution were also violating it. And so because there's this deep, rich history of legislative prayer, it's kind of like this problem. When you read the majority opinion in Town of Greece, there's a dance going on. And the dance is kind of like endorsement, not so much, lots of history, this has to be okay, some words at the end, we're going to move on now. One of the most vociferous dissents from the past term, Justice Kagan, when she went after this majority opinion, she was, shall we say, not pleased. I recommended reading to everyone. She happens, in my view, to be the best writer on the court right now also. So that's kind of what we've got in our model. You identify discrimination, there's a problem. You don't, there's no problem. What are the takeaways? I want to just emphasize a couple of takeaways. What does this mean for us? First of all, as I've tried to emphasize, limited protections for minorities. We're not asking how do minority groups feel in the process. We're not asking whether or not they're burdened. We're asking if they can identify discrimination. If they can't, they're going to have a challenge. But one of the other pieces I want to emphasize is what used to be a legal question now becomes a political question. Even in Employment Division v. Smith itself, Justice Scalia says, well, if you want to be accommodated, then I'll tell you what to do. Go to your legislature and lobby. And that's kind of a good way to think about at least what the next steps are. So if I were kind of to characterize all of this, it would really be about the primacy of politics now when you're dealing with church and state. And it's not surprising that if you go through like the federal code, you'll find that there are over 10,000 legislative accommodations. They range from like all different kinds of things. Some of them are huge, like the Religious Freedom Restoration Act, a federal act that was passed basically to overturn Employment Division v. Smith and that's a whole topic for another time. But that's a broad and huge attempt to accommodate religion. The court won't give it to you, the legislature. But you have small things, I mentioned this to you before. If you look at statutes and states, what they'll have is a little carve-out for sacramental wine. Minors aren't allowed to have wine unless, and then there'll be either something that says sacramental or the parent is there or something along those lines, each state with a different text in order to deal with kind of the problems either little small accommodations, big ones. I want to show you one more. It's one of my favorites. I'm sure you've seen the way in which questions about kosher slaughter is sweeping Europe. So what about in the United States? United States, of course, kosher slaughter and halal slaughter is okay, right? We would just assume it has to be the case. Well, it's actually a funny thing. Here's what our statute says. The only way you can slaughter, according to paragraph A, is by a single blow or gunshot or an electrical, chemical, or other means that is rapid and effective before being shackled, hoisted, thrown, cast, or cut. And if we just had A, there would be no kosher slaughter. But then there's B. And here's this is in the federal code. You open up the federal code and it says, no, you can also do it by slaughtering in accordance with the ritual requirements of the Jewish faith or any other religious faith. What we can't get via the free exercise clause, via the Constitution, we get through politics. People explain and lobby and say there are religious interests at stake, there are important practices at stake. The Constitution may not give it to me, but you can give it to me through the legislative process. And what's true for the free exercise clause is also true for the establishment clause. Representation before town boards and things along those lines now come not because we say, prayer has to include everyone. What it's really about is saying, we're here and want to participate. What you can't get through the Constitution, you now have to get through politics. And so kind of when I said at the outset that this is about protecting minorities from law to politics, that's really become the answer to the question. Increasingly, the protections that are given to religious minorities don't come as significantly through the law, but increasingly can be found in these types of political maneuverings. Thanks. Yeah.
Just one question. That may be fine for minority groups that have already been acculturated and accepted into society that they have a voice in politics. But what about minority groups that don't have a voice in politics and also don't have legal protection? It seems, according to this, that they would have nothing.
Well, they surely would have struggles. And that's why you see the increasing creation of NGOs around the United States that take up the cause of various types of minority groups. You see it on the religious side via litigation, for sure, the way in which you'll have like a Beckett Fund for Religious Liberty. And they'll take on the cause of all religious groups. I think they have a phrase from something that starts with an A to Zoroastrianism, but I don't remember what the A is. And what they're trying to convey is, we recognize that there needs to be an institutional infrastructure that provides this type of, access to this type of political and legal machine, and we're going to provide that for everyone within a particular space. And it means that institutions like that are more important and likely to get more funding and likely to play a bigger role in how minorities are treated in the U.S. Yeah.
Going back to the legislative prayer case.
Yeah.
Is there any consideration of atheists?
So I mentioned the names of the two plaintiffs. One of them is an atheist.
Right.
And she was, for obvious reasons, not enthusiastic about the monthly prayer.
Trying to set it up.
Yeah, right. I want a variance, and that's what's going on. So for sure, there most definitely is. There most definitely is. It is. It probably is. No, it's a client. There definitely is, and dealing with the atheist question is a little bit harder. On the endorsement side, you'll see the way in which the court will often try to capture it all by saying there can be no endorsement, and so atheists as well can't feel like outsiders, and that creates a problem every time you have public displays or public prayer or anything along those lines. Very explicit. There's also been certain cases where you will have certain religious protections expanded to a degree where they'll also seem to capture what look like non-religious concerns that work in the same way. This happens in the draft cases. So I may have a religious objection, but also philosophical objection kind of gets raised to fit into that category. But it's a complicated question. There's a lot of writing that goes on right now. What do you do? Like, how can we have this subset of religion that's distinct and different from all these other types of very important types of faith and identity claims?
It's likely to be a battleground because there's increasing numbers of atheists. Right?
There definitely is. And I would say the more common move, I would say there are two ways to do it. And some people say, and here's the language you'll have some people using, should we level up or level down? Meaning religion here, for what seems to be for largely historical reasons, should we raise everybody up who kind of fits that category to also receive the same protections, or do we push everybody down? My instinct, may not be surprising from the protectionists, to level everybody up. But this is a conversation that's ongoing, I would say, right now for reasons I think you're identifying.